Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about family mediation. Family mediation is an alternative dispute resolution method for divorce and child support and child custody cases. And the idea is to reduce the costs associated with litigating any issues between the parties in court by having them meet with a neutral third-party mediator to resolve any issues between them. Usually the parties will meet with their attorneys and this neutral third-party mediator, and the mediator's job is to get all the issues on the table, figure out what needs to be resolved, facilitate communication between the parties, and help the parties reach an agreed settlement. Mediation may be initiated voluntarily by agreement of the parties at any stage in their case, even before a case is filed, but it can also be ordered by the court. Mediation is always mandatory in Illinois in cases involving child custody and visitation. But even if the mediation is mandatory, any agreement that the parties reach as a result of the mediation is voluntary between the parties. So the mediator can't force the parties to come to an agreement. In cases where mediation is mandatory, Illinois Supreme Court Rule 923 requires an initial case management conference to be held within 90 days of the domestic relations petition being filed. And if by that time the parties are not in agreement regarding parentage issues, then the court will schedule a mediation. And within 30 days of the mediation, there will be a full case management conference that's going to be held to wrap up the case if it was successful or to proceed to litigation if the mediation was unsuccessful. In Cook County, the court will assign a mediator, and the parties are not responsible for paying the mediator's fees. In other counties, the parties mutually agree on a mediator, and the court only appoints one if the parties can't agree, and the parties are responsible for the fees. The court might decide how those fees are going to be paid between the parties. Something that's really important to understand is that discussions with the mediator are confidential, so anything that happens in a mediation can't be used against you later in the case. Everything that you say during the mediation is confidential. The parties can choose to jointly retain experts to help them and assist them with settlement, and any opinions of those experts are also confidential and can't be used later in litigation if the mediation isn't successful. So there's several benefits of mediation. One is that the parties have more direct control over the process than in litigation. Another is that it provides a custom solution for your particular family situation as opposed to a win or lose outcome that comes out of litigation. Mediation has a higher rate of compliance than orders reached through litigation, and it's less likely to be relitigated after the fact. So parties that get to come to their own agreement tend to follow that agreement more than something that's resolved by order of the court. Mediation is private. Like we said, everything that happens is confidential. Litigation creates a public record of all of your family disputes. So everything that's litigated is going to be a matter of public record. Everything resolved in the mediation is going to be private. Along the same lines, during a mediation, the parties are able to speak freely and vent their concerns and even apologize to one another without their statements being used later against them in court because, again, everything's confidential. And typically, mediation can be more cost-effective than litigation because you're not paying attorneys to go and fight over these issues and have several court dates, motions. You're getting it all these issues resolved with the mediator on the spot. Mediation's great, but there are several situations where mediation can be inappropriate. One is when there's an imbalance of power between the parties. Another is if there's a threat of violence or a history of domestic abuse. If the parties are not, one of the parties is not mentally or emotionally competent, mediation isn't a good option because you need the attorney to represent your interests in court. And if one of the parties is making unwelcome reconciliation advances to the other party, mediation also usually isn't appropriate because that can be a forum for that and not much can be accomplished if one of the parties is trying to reconcile and the other party doesn't want to. Let's go over the process for mediation a little bit. So once a mediation is held and all the parties are together with their attorneys, the first thing that happens is a joint meeting between all the parties, their attorneys, and the mediator, where the mediator and the parties will work to define the issues and decide what needs to be resolved. Then the mediator will do something called a caucus, and that's where the mediator meets individually with each party and discusses the issues with each party, trying to find out where that party is coming from. Then there will be additional joint discussions and individual caucuses with each of the parties until a resolution is reached, or the mediator and the parties decide that a resolution can't be reached on some or all of the issues. At the end of the process, the mediator will prepare something called a Memorandum of Understanding. And in this Memorandum of Understanding, the party lays out what agreements the mediator lays out what agreements the parties reached and any issues that still remain unresolved. If any issues are resolved, and especially if all of the issues are resolved, then the parties' attorneys will draft a final settlement agreement, which is going to be filed with the court, and that's what makes the results of the mediation official. Mediation can be beneficial even if the parties don't reach an agreement, because it serves to clarify the issues in the case, and it makes the subsequent litigation less expensive because the parties and the attorneys know what's in dispute and what's not. And by clarifying those issues, it makes settlement a lot easier after the mediation happens if the mediation isn't resolved on the spot. So there's a lot of cases where the attorneys will be able to settle shortly after the mediation because of the mediation process. So if you have any questions about family mediation, or if you'd like to hire us to either be your mediator or to represent you in a mediation, you can call us at 630-324-6666. We offer free consultations for family mediation or almost any other area of law. If you want to see more videos or podcasts or read articles on almost every subject of law, you can go to learn-about-law.com. If you want to check out our business podcast where we interview business owners, go to seizeyourbusiness.com. And finally, we have a new real estate podcast called makingrealestatefun.com where we discuss issues around real estate. I want to thank Tom Weiler from Weiler Studios for being our videographer today. If you like his work, you can go to weilerstudios.com, and he'd be happy to provide videos for you, and that's Weiler with a Y. Thanks so much for listening. We love your comments and questions, so please feel free to comment on this post. Thanks.